to make. Reading this final regulation and comparing it to what came out a year ago, I think it's very clear to me that the Department of Labor really listened. They had over 10,000 comments. They had public hearings for 5 days. They had 2,400 pages of testimony from all that. And it's very clear to me that the department listened to all those people, and it's made this a much more workable proposal, I think, than the much more workable regulation than the proposal ever would have been. Let's go to the next page.
Jonathan, I want to ask a question here.
Go ahead.
Okay. Here we have on the phone many of the ministerial agents, most of them. So overall, in relationship to their business, as it relates to their business alone or as it relates to working with fiduciary doctors, is this final regulation positive to their business and to ours? Is it negative? Is it, give an overall report card.
Yeah, I thought about that. In fact, it's very clear that, and we have several audiences with us this morning. One of them, the advisor community, clearly listen up. This is going to impact your business very directly. It really applies to us very directly at Fiduciary Doctors, and I'll get into that over the coming weeks. But this is something, of course, we need to pay attention to. Not in our capacity as a 316 administrator, in our capacity as a fiduciary under 321. In those very two sentences I read, and mostly the first one, respecting plan management. This applies to us. Regarding our TPA and ministerial agents, essentially this is something you can listen to, you want to be aware of. In almost all respects, it does not impact your business. One exception I want to talk about at the end, which regards discussions about platforms and making platform providers available. This is, I think, the one place in your businesses where I think you need to really pay attention, and that's at the very end. That's the only thing I can think of. So, let's go to, we're on page 3. Okay. Simple goals. When I thought about this whole undertaking, I realized how mammoth it was. I started reading, and my head was spinning. I just want to give you my own personal relationship to what's gone on the last week. It's been a very intense week. I think for me it's going to be several weeks of really intense reading. I want to make it very clear this is very hard stuff. For anybody who wants to get into it, I think you're more than welcome, and congratulations. We ought to have a support group, and helping each other understand and get through all this. But when I started thinking about today, I realized I wanted to really keep this as simple as I could. There's so much here. I think I want to take this in bite-sized pieces, recognizing, again, that many of you are in the TPA ministerial agent business, and this really applies to you only personally. In the fact that I mentioned potential platform relationships, and that you're doing work with us, and you're doing work with others who are fiduciaries. So in that sense, I want to keep this very simple. And so I really want to make sure that any questions you have this morning, please feel free to ask. Two ideas. It's all we're going to really talk about today, which is basically what is advice. Advice is a recommendation. What is a recommendation? That's it for today. So you can kind of take a deep breath and realize that we're going to go very slowly. These two concepts, I think, are essential for understanding what is an exceedingly complicated law. So when we talk about this, I want to make this third point. you'll see that a lot of what I'm going to present to you today, when you really kind of sift through what the department wrote, a lot of it's going to sound familiar, because what they did, and I think they needed to do this, they really needed to relate this back to ERISA and the statute, and those two clauses I read, and to what we call the duty of prudence, to make sure that only the best interests of the plan participants and beneficiaries were carried out, that all expenses related to the plan are reasonable, and that that the duty to perform was based on a standard of what a prudent expert would do. These are the guideposts, and this is what really informs this regulation. You'll also see when we really get into it, how much is new. There's a lot of really good new stuff that actually should have been thought about and written 40 years ago, but we're getting into it now. And I think you'll lastly appreciate just how big an undertaking this has been for the department. Next. Page 4. There we go. Okay. So, what we have in all this, mammoth public record, hearings, thousands and thousands of comments. What happens here is that the department has defined who's a fiduciary investment advisor and necessary accompanying prohibited transaction class exemptions, which are going to allow a lot of people in this retirement industry, including broker-dealers, insurance agents, and others that act as investment advice fiduciaries, to continue to receive a variety of common forms of compensation. But this is really the big but that's kind of new. As long as they commit to adhering to standards aimed at ensuring that their advice is impartial and solely in the interest of plan participants. Again, taken right out of the original legislation. Let's go to the next page. So, going forward, what we have is a massive document that applies to advisors who provide advice to, and this is not a term in the regulation, it's a term that I've called covered plans. We're familiar with advice to plans, we're familiar with advice to sponsors, we're familiar with advice to plan participants and beneficiaries. We're also familiar with advice to other fiduciaries. The big change is that all of this now applies to IRAs and IRA owners. That's the big change. For years, I think the department has correctly recognized that the world is very different from the world of 1974, and that IRAs, which now have something like, take your pick on numbers, $7.5 trillion of money in investments, have been just the biggest loophole, if you will, for advisors to get around, because they were not covered by the prior rules, but they are now going to be covered, IRAs and IRA owners. Next. This is something that I really wanted to spell out in the most simple terms. What this regulation says is very simple, and this kind of explains 500 pages. Just these two lines. Going forward, what advisors are going to need to do is avoid receiving compensation that reflects a conflict, okay? Level payment, for example, everything's disclosed, clearly demonstrates in the best interest of the advisee. Or, if they can't do that, they're going to have to demonstrate that they have complied with a standard called the best interest contract, which allows for all kinds of things, including those which may on the surface look like they represent conflicts, as long as it can be spelled out that they are performing in the best interest of their customers. That's it. That's really all you need to know to understand this entire package. Okay, let's go to the next page.
Jonathan, before we go to the next page, so in the previous unveiling of the new regulations, a BICE contract was going to be needed in almost every situation that in dealing with a qualified plan, and we'll talk about an IRA later. Today, will a BICE contract be needed in almost every situation, or how does one demonstrate that there are no conflicts, and I guess I'm giving away a little bit, and not have to use the BICE? Or is that for a later discussion?
Yeah, you're getting into our discussion at the very end of today.
Okay.
For our entire discussion 2 weeks from today, and probably our discussion from 4 weeks today.
Okay. So, but is it enough to say
the rules have changed?
That
the rules
it has changed
substantially.
And so where before BICE was going to be needed, let's say always, now BICE won't be needed always if you can satisfy the above, and we'll talk more about it. Is that fair to say?
Yeah, and I'd even put it in simpler terms. And again, I want to come back to this because I think the flow chart for understanding this entire exercise is begin with this question, and we're going to get into this in a minute. Is what I'm providing advice? If it isn't, and we'll talk about that in the rest of this presentation, you don't even have to worry. This isn't covered. If it's advice and it's not conflicted, there's no need to resort to this contract. The contract is only necessary when on the surface advice does not appear to be unconflicted.
Thank you. That's what I wanted to say. So there's really 3 stages. There's it's not advice, which let's take for the moment they're right in that assumption. Number 2, it is advice, but it's not conflicted. Or number 3, it's advice and may be conflicted and needs a BICE contract. So those are the 3 stages, and we can talk more about it later.
The flow chart. That's the flow chart for everybody to keep in mind. That's kind of how I summarized this when I got to the end. I said, okay, this is simple. Have what I did, have what my employees, have what we've done constitute advice. If no, we're done. Yes, no. If it's yes, we get to the question whether it's conflicted or not. If it's not conflicted, we're done. If it appears to be conflicted, and even then there are some exceptions, now we may need to resort to the BICE. The BICE is a much more workable concept than it was in the proposals. That's all I really want to say for now.
Thank you. I just wanted you to make that point clear. Thank you.
Okay. Now, let's turn to page 7. I mean, this is really kind of an overarching comment. Under these new exemptions adopted by this regulation, firms are going to be required to acknowledge their status and the status of their individual employees, their advisors, not just the firm, but also their individuals, as fiduciaries. And the firms and their individual employee advisors are going to be required to make prudent investment recommendations without regard to their own interests. This is really the sum and substance of it. Or the interests of anyone other than the customer. Only reasonable compensation can be charged. No misrepresentations, no misleading statements to customers regarding recommended investments.
What if I'm not a fiduciary? Do I have to acknowledge that?
No, if you're not a fiduciary, you don't have to acknowledge it.
Right.
So you don't have to acknowledge what you're not. So that's another very important point. And again, we'll get into this. First question is, am I giving advice? If I'm not a fiduciary. I'm done. I go home and I can do anything else. This is only aimed at people who provide advice, and that's really the focus of the next few minutes.
Well, and that was a big victory for the financial industry, because remember, silence has always been a very powerful tool that they've had. So if you remain silent, your client, the plan sponsor, really doesn't know that you're not a fiduciary, because you don't have to disclose you're not. And only those that have to disclose are those who are fiduciaries. And we'll talk more about that later, but and the role that fiduciary doctors will have to play in that. So thank you, Jonathan.
Yeah, I mean, going forward, I think it's
Hey, Jonathan.
Yes, go ahead. Is this?
Sorry, this is Chase Cannon.
Hey, yes, Chase. Good to hear from you. Go ahead.
You as well. I appreciate you taking time to do this. My question is on the advice side of things. Is this just applying to investment advice, or is this advice on plan structure, how the plans run, things like that?
We're going to talk about that. And again, you're asking a question which gets to something I'm going to spell out in the next couple minutes. But
okay.
It does not apply. It does not apply to anything that's outside of those two clauses which I read at the very beginning. Investment advice for a fee, having discretion over plan management. That's what this is all about, and that means assets. It doesn't mean having the discretion, for example, to decide whether a plan's going to have a loan or not, or if it's going to have an automatic enrollment feature. That's outside of the scope of this regulation. Again, that's why I read those two clauses at the very beginning. That's where it all comes from, those two clauses, and then we go from there. Okay, so let's go to the next page. What's advice? It's just really simple. Yeah, I really want to cut through all the confusion in this. It's about making a recommendation. If you remember that, I'm trying to keep this simple and cut through all the fog. Advice is making a recommendation. Okay, let's go to the next page. I keep getting this signal that we can't allow any more people to come
Well,
in.
yeah, this is the first time our capacity is about 30, and I guess there's people trying to get on, and we've never had this happen before, so we'll look into it for the next meeting. But it just means it's full. For any of you that are in the same office with each other, if, we haven't certainly needed this before, but if you are like one person's using a computer in one office and one's in another, if you could try to go join into the same room, that would allow more capacity for other people and get, so that we open up some space. But go ahead, Jonathan.
Sure. Okay, now we really get into the heart of it. Again, advice is a recommendation. That's all you need to remember. Now we go, okay, what's a recommendation? They spelled it out. They said, first of all, advice regards the advisability, and I'm putting this in black because it's a carryover from the 1975 regulation. Regards the advisability of buying, holding, selling, or exchanging securities or other property. Okay, and that's just a carry forward. The blue, whenever you see blue going forward, that's new. What it says is now, in addition, advisability, buying and holding, including recommendations for the investment of securities or other property after the securities or property is either rolled over or distributed from one of those covered plans, including an IRA. And that's another huge change. That's where they really focused a lot of attention in the proposal, but they've made that more workable. But just understand, recommendation is the same as it was about advisability in buying, selling, holding securities, property, but now includes this additional concept of making recommendations after property has been distributed or rolled over. Next, this is all new. We had this sentence in the original legislation which said you're a fiduciary if you have control over plan management. It's taken almost 42 years, but we now have a document which spells out what that means. So, what is management? Management includes recommendations concerning the management of securities or other property, including recommendations on investment policies, strategies. How many people on this call have seen an investment policy statement? That's all now clearly going to be considered advice because it's a recommendation concerning management of plan assets. It includes recommendations concerning portfolio composition. You should have 60% of your assets in securities. Of that, half should be in international securities, half should be in domestic securities. The remaining 40% should be in bonds, fixed income. Not clear under the prior regulation, but that's now clearly considered a recommendation on plan management, clearly going to be considered advice, making the advisor a fiduciary. Next, management concerning recommendations on people to provide investment advice or management services. So now I'm clearly a fiduciary if I'm also making recommendations concerning who to recommend for investment of plan assets, an advisor, someone who has fiduciary duties. So if I recommend that person, I'm making a recommendation on a management issue. I'm now a fiduciary. Making recommendations on the specifics on the selection of investment account arrangements. You should do this in a brokerage account. You should have an advisor. You should have a fee-based advisor. You should have a commission-based advisor, whatever. That recommendation is now going to make you a fiduciary. And this is the last one. This is clearly what the department aimed at. Any recommendations regarding rollovers, distributions, transfers, really going to be considered recommendation on a management issue. And I put in bold any of those recommendations, including whether to take a distribution or not, whether to make it a rollover or not, clearly going to be now a management decision and clearly going to make that person a fiduciary. And if the answer is yes, you should do this. And the second question is, okay, in what form should it be? A rollover, a distribution, a transfer? That additional part of it, that additional component, that twig on that branch is going to make that person a fiduciary. Okay, let's go to the next page. Page 10. There we go. Okay.
So, Jonathan,
yes, go ahead.
In our education meetings, the question always comes up, hey, can I take the money with me wherever I go if I were to leave the company? And we always, yes, you can take the money and you can transfer it or do what you would like with it. And we usually tell people just in general, hey, we would recommend that you roll it to your new plan. Are you saying that that would be considered advice?
Yes.
And that we could be on the hook for that if something goes bad in that plan?
Correct. That's exactly the point. Now, I will talk at the very end about what's education and how far you can go when you want to say, okay, I'm not a fiduciary, I'm just an educator. But that's a very important point. Yes, if you're making that kind of recommendation, again, about whether to take a distribution, whether to take a rollover, whether to transfer, and in which one of those three options you should do, that's now going to be considered advice. Okay. Now, this is also very important. The next logical question, okay, you've told us that advice is a recommendation. You've told us that a recommendation includes a discussion about the advisability of buying, selling, holding. It also includes recommendations about plan management. Okay, now, what's a recommendation? This is also a big departure from the proposal, and clearly represents, I think, a victory for the advisor, the broker-dealer advisory community, and this is what they said. Okay, a recommendation is a communication, and this is based on a entirety of the context, viewing the content of the communication, the form of the presentation, as well as the context in which it is presented. That is the basis for determining whether something is a communication. And this is really what's important, what I put in blue. That would reasonably viewed as a reasonably well-informed person, as a suggestion to engage in, and then the next is really important, to engage in or refrain from taking a particular action. So, if you were back at that employee meeting and you said, look, I think you should refrain from taking a distribution. I think you should leave the money in your plan. There are all kinds of reasons. We've identified low-cost funds. You're going to be in a much better position if you leave your money in this plan than if you take it out. I think that's very clearly intended to make that communication considered a recommendation. Other language, this is all in the preamble.
Jonathan.
Go ahead. Yes, Don.
I want to make a point of how slippery a slope this is. Notice the word suggestion and just the word recommendation. I think in my notes I put the word putting my 2 cents in. And so Chase asked the question, if someone says, can I roll my money over? And the answer is yes. He hasn't made a recommendation. He's just answering a question. If he adds to it, but if I were you, that's where he puts his 2 cents in. Now, the point here is, I think that it's going to be natural in the financial community to say, oh, wait, we dodged a bullet here. We don't have to say if we're a fiduciary or not. Boy, everything's fine. Well, on the surface, that's true. But the minute you give, quote, your 2 cents, then you are a fiduciary. So now the question is, since you want to be a non-fiduciary, then you have to use the BICE because you are conflicted.
Not quite. I want to get into that because I think there's an intermediate step, which I do want to conclude with today.
Okay, thank you. I'm not trying to get ahead of you. Thank you.
No, thank you. It's very, very clear that there's an intermediate step, which I want to end today's conversation with. But you're right. I mean, this looks nice. It looks very simple on the surface, but it is a slippery slope, and it's really important for people to understand how very quickly you can be you can be in the fiduciary world. I was thinking of trap, prison. No, it's a status. That's all this means. And then if you're in that status, you've got to do certain things. But it's and this is really the next point. The more individually tailored a comment is, the more likely a recommendation. So yeah. So if I say, again, going back to your example, Chase, thank you, it's a great one. And you know this particular person who's asking the question, you say, look, you're 30 years old. I think you'd be nuts to take this in the form of distribution and pay taxes on it. If I were you, I would roll that money over into your new plan. In fact, we know that plan. We've done some work for it, and they've got some great investments, very low cost funds, so on and so forth. Yeah, this is not black or white. It's a continuum. It's a spectrum. The more individually tailored, the more likely it's going to be considered a recommendation. The more generic it is, the less tailored, the less likely it's going to be considered a recommendation. But I'm sure there's going to be a lot of litigation on this very point because it is fact-based. And that, I think, is going to invite litigation and in fact, a new area of trial lawyers, not just the Sleeker firm, which is litigating the subject of whether expenses are reasonable or not. This is going to be a litigation over whether I made a recommendation or not. Entirely fact-based. Last point on this slide is a very important. This is also a big win, I think, for the industry, for the broker-dealer advisory community. This concept of a subjective contextual basis for making this judgment call is intended to be consistent with FINRA guidance, the Financial Industry Regulatory Authority. Okay, let's go to the next page. Now, also, very important conditions for a communication to be considered advice. Got to be made in the context of relationships that exist for the recommendation to even give rise to a fiduciary investment responsibility. And this includes recommendations that are made directly or indirectly. And we'll talk about that is through an affiliate by anyone who represents. This is the first way. This is the first way you, and I keep seeing these signs, we've got too many people, so it's covering up my slide here. Anyone who says, I'm a fiduciary, okay, now you're dealing with someone who's clearly a fiduciary. By just acknowledging that they're a fiduciary, they are a fiduciary. The second way, you have to demonstrate that you're a fiduciary is if you do all these things and you do it based on a written or verbal agreement that the advice is based on the particular conditions, the particular contours of the risk profile of this particular advisee. Or, and this is the third way. A person can be a fiduciary. They have to pass one of these three tests in addition to everything else. They have to direct the advice to a specific recipient regarding the advisability of a particular investment or management decision regarding securities or other property. So you have to go back to those other builders, if you will, and if you do that by directing to a specific participant or any kind of advice recipient, either one of those two ways that advice is called, either advice regarding the advisability of buying, selling, or holding, or making any kind of recommendations about management decisions to a specific recipient. It will also make you a fiduciary, even if you don't acknowledge it as you do up in the first bullet. So, again, these are all conditions that you have to have one considered a fiduciary. Okay, let's go to the next page. Also very important to understand, all this has got to be done. It's done in a vacuum with no money changing hands. Again, nothing to worry about. But now again, that's a very important point because you have to demonstrate that there was a fee paid for this recommendation, and it can be direct or indirect. So you might ask, common examples from my own experience. I can't tell you how many times in the last 15, 20 years that I've been asked by platform providers, would you like to come to our box and watch a football game? Would you like to go to our annual convention? It's a 4-day deal. We'll pay your transportation, we'll pay your hotel, and so on. Again, I think there's going to be a lot of litigation over this. Is that an indirect payment? I think that in my example it would be, and that's why even before these rules, I refrained from accepting that kind of compensation. Okay, so it's a direct or an indirect payment, something that is explicitly determined and called a fee or other compensation for advice. I am charging 10 basis points for this advice based on your assets. That's my fee. That's the first bullet. And it's got to be received either by the advisor or and this is for firms which have multiple organizations, including advisors, including 338s and so on. And the compensation or fee is received by an affiliate from any source. So if you start breaking down some transactions that I've seen, you have 6 or 7 different intermediaries between the payor and the recipient. And this preamble on this particular point in the regulations very clearly says, even it doesn't matter if it's from any source. So if you go up the line and you have to trace 4 different levels of payors, but they indirectly wind up in my hands, I've received a fee or compensation. Now, another very important point. All this has to be done in connection with a transaction or a service. So a transaction, of course, would be a buy or a sell. A service would be a management advice regarding how to allocate your assets, whether you should have international stock or so on. So this is all got to be put together in that kind of context. If it isn't, again, you can argue that you haven't received a fee. And I think this is kind of logical. So if I'm getting something, I'm receiving something, but it's not in conjunction with a service, a management service, or a transaction. It's in the context of giving advice or automatic enrollment. Back to the first question. I think that's clearly intended to be outside of this regulation.
Jonathan,
yeah, yes.
This may be beyond this discussion today, but let's say I was with Merrill Lynch, and it's not uncommon that in order to be on the preferred hit list, when people call in for a particular platform, that platform has paid to be on the bronze level of, on the platinum level of recommendation, because they have paid for that. So going all the way up the line there is a compensation that's been paid.
Absolutely. Absolutely. The solicitation fee, the bonus, the volume, compensation. I read these regulations and say that's all open for coverage under this regulation. Those very common practices, the solicitor pays someone to bring in business, finder's fee. There's some bonus paid 4 levels up from this organization, bonus for having $1 million of new investments brought in this year. Don't get anything if it's not at some predetermined level to be paid a bonus. I think that's all intended to be covered under this 3-word bullet from any service, from any source, direct or indirect. So does that answer the question for now?
That is yeah, that's enough for now. But that's mind-boggling, because if again, I'm with Merrill Lynch and John Hancock has paid $1 million to be on the platinum list, or whatever you want to call it, and then I, as a broker of Merrill Lynch, use John Hancock, and I know we're going to talk about it later. Indeed, is that creating a fiduciary position? Let's just leave it open for now. But the point is, it's a very slippery slope. That's the
So when you think about all this again, I want to go back to this because I want to make this too hard for today. Two things you have to determine: is this advice, is it recommendation? Does it exist within the context of these other points in connection with a transaction or a service? Is there a fee? And if there is, you know, I think you have to say that's probably a fiduciary act. However, even and you have to either commit that what you're doing represents no conflicts, and you demonstrate that. And again, this is really something we're going to cover 2 weeks from now in much more detail. You can demonstrate that, you're all set. If you can't, you're going to have to go into this loop called the best interest contract exemption, where you will always have the opportunity to explain why what you're doing does not represent a conflict. So I just want to, again, I want to go back to that, and I want to drill that down and repeat that message. Before we leave this page, I want to just, no, let's go back to 12. 2 very important points I want to make sure everybody understands, and these are really important to understand. This fee is only going to be considered a fee or other compensation in connection with advice if it would not have been paid but for this service or this transaction. So you have, again, it has to all relate back to this service or this transaction, and it would not have been paid but for this service or this transaction. That's one condition. Or and this is really where you get into all this other stuff, Don, that the eligibility for this fee or compensation is based solely on this service or this transaction, nothing else. So
But for rules are always helpful in the sense, well, they're not helpful to figure out, but I mean, I know that when I actually worked at DOL, you know, we had to look under reasonable compensation under 408C2 as well as B2 in relationship to certain types of transactions where people were reimbursing themselves. And so, so in other words, if you're the fee or compensation is used as a general fee that, say, Hancock pays to have, or somebody pays Hancock to have their fund on the platform, but the fee is paid regardless of whether you, the client, selects the service or the transaction. So that fee is paid anyway, you know, whether you use that service or not. So whereas if you're then paying an additional fee to create a service or a transaction involving that fund, then it's a payment. So it does get kind of squirrely, but you know, again, it's whether it's specific to the service or the transaction.
So I think what you're saying, Lynn, is something that I think is very, very important for everybody on this morning to understand. In your capacity as an investigator for the department, ending 10, 11 years ago, the department was actually taking actions, making decisions regarding enforcement on this conceptual basis, even before it was really a part of the law of the land. And I think that.
Well, I mean, it's in relationship to 408C2, which we rarely deal with. But the but-for I mean, I just can see my old supervisor, Phil Tanner's, you know, talking to me about the but-for rule.
I mean, so this now made its way into the regulation, whereas it might have been more informal. I guess the way I'd put it. And the department took all these informal experiences. And again, this is something else I think I surmised as I was really getting into this. And again, relating to experience like yours and my experience with investigations and audits and so on, it's now made its way into the law of the land, and I think it's a very logical interpretation. So let's just move on.
Yeah. No, and so, I mean, it does get I mean, the context where I learned it was like overhead costs versus direct costs. Like if somebody, I guess it was more in the context like, okay, if a Teamster fund was located in the same building as the union, could they reimburse for rents for certain things? And so they could reimburse for the heating used for that area. You know, they could, for the direct expense that they use for the service of the transaction, but they couldn't pay for something that was just like an overhead cost. And I think, you know, I don't know whether that just made everybody more confused, but, you know, that like, that everybody paid just because they were part of building. They couldn't pass on something that didn't actually impact, you know, the overhead, the sort of miscellaneous costs that, you know, were too amorphous, you know, to be, but they could pay for somebody's direct time and expense, like if there was an administrative service provider and her time was accounted for, you know, it could pay for that, but it couldn't, you know, there had to be a reasonable explanation as to how you allocated costs, and I think it's the same concept. I just really hope I didn't confuse people, but that's how,
Yeah.
what?
Econ 101, the difference between fixed overhead cost and marginal cost related to a specific, an additional act. So I want to move on.
Right, right. And that's really all they're talking about. You know, so in other words, if it was paid but not for the service or the transaction, then it doesn't have to be included. But it does get dicey in terms of parsing that stuff out.
Sure does. I mean, I'm trying to simplify all this, and you realize for some of these concepts, yeah, we could spend an hour or two or three or four just spelling out various hypotheticals on whether it is or isn't. But yeah, I think that's good. But I am mindful that we're now 6 minutes before the hour, and I want to move on. So let's go to the next page. Relatively simple, but this was, again, also explicitly mentioned in the regulation. This compensation, for example, and again, this is all very common, includes commissions. In case anybody had any doubt, no longer in doubt. Same with loads. I remember a few months ago I talked about the GEO economic impact analysis, and the department spent a lot of time talking about loads, front-end loads, rear-end loads, and they mentioned this, they carried this over into the final regulation. I'm not sure that that's really a typical part of retirement industry compensation in the year 2016. May have been, but there it is. Certainly finder's fees. We were talking about this. Bonus payments, volume bonus payments, solicitor's fees, all explicitly mentioned in the regulation as compensation. Revenue sharing payments. In case anybody had any doubt, this is also very clearly considered compensation. Okay, now let's go to the last page, and this is kind of where I want to end today with a couple of comments if I can get them in before we get to the top of the hour. Okay. So we now get to the point where we say, okay, I got it. I think I understand this concept of advice. Tell me what kind of communications, what kind of activities may not be considered or will not be considered advice. Okay, so general. Let me begin with the new ones. General communication. So if I'm having this discussion with you all this morning, and I'm making some general discussion about you know, specific investments, but I'm doing this in a public way. I'm not tailoring anything. I'm not directing this to anybody in particular. Common for radio shows, talk show hosts, so on and so forth, talk about these issues will not be considered advice. The next one that I think is really worth talking about is this whole concept of making available a platform provider, because this is reality in the year 2016, and I think this is what the DOL recognized when it looked at all the comment letters and all the testimony about the proposal, which would have said all of this, but it made it almost meaningless. So what the DOL has recognized is that service providers, like this, record keepers, many of you on this call, third-party administrators, often offer a platform or a selection of investment alternatives to plan fiduciaries who actually choose the specific investment alternatives that are going to be made available to their participants. DOL says we recognize this as a very common practice. Okay, but simply making available a platform or investment options without regard to the individualized needs of the plan, its participants, beneficiaries, if the plan fiduciary who's getting this information is independent of the service provider, again, the record keeper, the third-party administrator, that will not be considered communications arising to the level of recommendations. However, and this is really important, the provider, that is the TPA, the record keeper, is also going to have to as part of the condition of relying on this exception to the advice concept. Service provider is going to have to represent in writing to the plan fiduciary that they are not undertaking to provide impartial advice, investment advice, or to give advice in a fiduciary capacity. It's kind of just a throwaway, but it's there, and it's going to have to be done in order to invoke this particular exception. Education. I want to go back and talk about education because I know that's on the minds of a lot of people, and this has been the subject of an awful lot of energy in this entire process over the last year. Essentially, the exception that the department has worked out in the final regulation says that any specific discussion of investment alternatives to be included as examples in the presentation of hypothetical asset allocation models, including any interactive investment materials. I tell you answers to 20 questions, and you determine that my risk profile is in the bottom 2% of risk tolerance. Anything that's provided in that context, including, as I say, examples in a hypothetical asset allocation model, or those interactive materials, intended just to educate participants about what their investment options are, will not be considered advice, will be considered education, so long as they are, and this is really important to understand, designated investment alternatives, and that they're selected or monitored by an independent plan fiduciary, and certain other conditions are met way outside this discussion. So I think what the department did, it really listened, and it understands the real world, that a lot of interactive materials are used to present hypothetical asset allocation models, discussion of hypothetical allocation models without tailoring them to the specifics of a particular individual will be considered advice, will be considered education and not advice. I want to just talk very briefly about the last two, and these are important, and I want to talk about what we're going to do in the coming weeks. Clearly, work that's done by employees of a sponsor, getting payroll records, and administrative information regarding a particular plan. In that context, as long as those people are not receiving additional compensation and just getting paid the regular salaries, that's not going to be considered advice. And the last one I want to talk about, because it's really important, this was expanded tremendously from the proposal. Essentially, if I am a sophisticated investor, and that's very specifically defined. I manage a plan that has at least $50 million, down from $100 million in the proposal, but now just $50 million. Or I'm with a registered investment company, a bank and insurance company. Conversations that you have with me, you can be confident that you can't roll me, that I know what I'm doing, and a transaction with me on those two conditions will not be considered advice. No one with that kind of information, that kind of expertise, should really have any kind of idea that what you're going to tell me doesn't add up. So that's the end of today. I just want to say a couple quick things, and this is really to put everything in context. I know we're running over a little bit. The DOL listened to everybody when it talked about how difficult it would be to change practices developed over 40-some years and make those changes overnight. So the department has actually extended in general the application of these rules to exactly 1 year. Pick your date, April the 8th, Friday, April the 8th, when the regulations were put in the public register, in Federal Register, or April the 6th when they actually came out. But it's 1 year. It's 1 year from now, minus a couple of days, when all this goes into effect. So what we're going to do is keep reading and thinking and talking, and invite you to join us in all that as we continue to really develop our own understanding of all this. When we talk next time, I'll talk about this concept called the best interest contract exemption. It's very important to understand. It's the out that you will have, even if you've done something, you are doing something that has the smell of a conflict. That's it. Thank you all for joining. We'll see you on the 27th of March, or 27th of April, 2016. Have a great rest of the day. Until then, bye-bye.
Thank you, Jonathan. Bye.
Thank you. Yep.